My name is Schahrer. I'm a senior associate here with the law firm of Boatman Ricci, and we're here for your weekly Florida case law update. I'm here with Liz Thomas, our law clerk and recent graduate of Ave Maria University, and we're here to talk about a pretty interesting case that recently came out of the Second District Court of Appeal. Liz, do you want to tell us what we're talking about today?
Absolutely. Like you said, this case is very interesting for a variety of reasons, but basically to sum it up, it involves a man who was attending a baseball game who approached a sheriff's deputy who had a canine and was ultimately bit by the dog.
Now, interestingly enough, Liz, Florida has a statute that actually deals directly with dog bite cases, generally speaking, correct?
Yes, that would be section 767.04, which basically says it generally imposes strict liability on the owner of a dog who bites a person in a public place, or even if that person is lawfully in a private place, including the dog owner's property. But in this case, the court held, due to the government's sovereign immunity, that the statute doesn't apply.
Yeah, now sovereign immunity is kind of an interesting animal. It's rooted in the historically in the American system, that basically the idea of sovereign immunity is we're not going to hold the government accountable for certain acts. Just from a public policy perspective, if people were able to relitigate how the government handles certain discretionary acts, such as how the government fought a fire or dealt with a national emergency, well, then we probably have more lawsuits than we even do in American society. And so, but sovereign immunity kind of breaks down to two aspects. The court's going to consider whether the act of the government, in this case, the sheriff, was discretionary or operational. So, quick example, operational would be if we are fighting a fire, if the fire truck was driving to the fire and it happened to be negligent and hit somebody on the way to the fire, well, then that would be an operational aspect, and the government might be held liable in that case, depending on the facts. Discretionary would be how the firefighters then fought that fire. So you wouldn't be able to litigate if your house burned down, how the government could have better fought that fire, but you might have a case if they had been negligent on the way there. So that's a quick, easy example. And in this case, they found that the sheriff's act of patrolling this public place was operational, right, Liz?
Yeah, exactly. And because that they found that it was operational, the court moved to a traditional common law negligence claim, which basically says to state a cause of action for a negligence claim, the plaintiff has to allege 4 elements: existence of a legal duty owed to the defendant and to others, a breach of that duty, injury to the plaintiff, and then actual losses or damages resulting from that injury. And in this case, they focused on the zone of danger, right?
Right. So they looked at the zone of danger, and interesting, the sheriff tried to actually pin this back on the plaintiff and say, you shouldn't have been near the dog. And so you essentially invited the dog bite by coming near the canine that was with the sheriff who was patrolling the area. But the court rejected that argument and said the officer, by being in a public place, actually created a zone of risk by bringing that canine in the public place and failing to warn any members of the public not to approach the dog or otherwise engage with the dog. And they rejected the argument, and I thought the court made an interesting point. They said, otherwise, the sheriff would be empowered to patrol this area, and what the court says is continually watch passersby get bit by this dog with absolutely no duty to the public to warn that the dog is either aggressive or should not otherwise be approached. And so in this case, under an exception to the doctrine of sovereign immunity, the court sent the case back down and affirmed that the plaintiff had stated a cause of action and could proceed against the sheriff's office on this negligence action.